Okay, good morning, everybody. Today is Monday, February 6th. It is 9 a.m. We are in conference room 325 at the state capitol at 415 Bishop Street. Today we have a info briefing. I am the chair of the Corrections, Military, and Veterans Committee. On the left to me is the chair of the House Judiciary Committee, Chair Tarnas. To his left is Representative Ganadin and Iligan, and to my right is Representative Chan and Souza. And I will leave it up to you to introduce the Senate side.
The Senate is very thrilled to be here with our friends from the House. And on behalf of the Senate, we have myself as the chairman of the Committee on Public Safety, Intergovernmental, and Military Affairs. To my immediate left is the chairman of the Committee on Judiciary, that is Senator Carl Rose. And to his right is my vice chair of the Committee on Public Safety, that is Senator Brandon Elefante.
Very good. Spoken. You have a better radio voice than I do.
I have a face for radio, though.
I will yield to the chair of Judiciary on the House side.
Thank you very much, Chair Hashem. Welcome everyone here today, and welcome to those who are watching us. This is a very important info briefing for us today because as we look at instituting reform in our pretrial detention system here, we need to look at a holistic approach and identify what are the best practices in other states throughout the country. And so in order to learn more about that, we've asked our national expert that we have access to at the National Conference of State Legislatures to come speak with us today. And if I may, Chair, introduce our speaker for today, Amber Widgery, who is an attorney and the program principal with the National Conference of State Legislatures Criminal and Civil Justice Program. And she'll be providing to us a national overview of the state of pretrial statutory policy and the overrepresentation of individuals with mental illness in the justice system. So we'll get to have a good sense of what are the national data, the statutory frameworks, and the legislative trends. So with that, I'd like to, if I may, Chair, turn it over to our speaker today. Everyone please welcome Amber Widgery. The floor is yours. Please proceed.
Thank you so much, representatives and senators, for joining me here today. I have a colleague actually that's on our Zoom line, Laura Carper, who's hopefully going to share a slide deck for you now, and I'll be referencing some of what's on here. So thanks to Laura, who's back in Denver, helping us out from afar. So as mentioned, my name is Amber Widgery, and I'm a program principal with NCSL. For those who might be listening at home, next slide, Laura, or may not be as familiar with NCSL, the National Conference of State Legislatures is the membership organization for the 7,386 now state lawmakers nationwide and more than 30,000 legislative staff in the 50 states, the territories, and the District of Columbia. We have offices in DC and the District of Columbia as well. And among our goals is to provide this kind of policy information and research to state legislatures. And we track all issues in all policy areas. And so I'm very grateful to be here today. Thank you for having me to be able to share some of this work with you. Laura, next slide. I want to just set a little bit of context first for the pretrial issues by sharing some national data to get a picture of where we're at now and who's in jail and what does pretrial release look like. And so what you see on this screen is a 40-year trend roughly of jail data using census data is that bottom blue line, and then jail data from the Bureau of Justice Statistics. And so this is looking at national jail populations. And what you see, or what is illustrated on this graph in particular, is that nationally the number of people who were held in jail grew basically fourfold in 40 years, and a much higher rate than the population in the US grew. And if you go to the next slide, Laura, what you'll see here using that same Bureau of Justice Statistics data is that over that same period of jail growth, most of that jail growth is driven by growth in pretrial incarceration. So the individuals who are held in local jails convicted, you see that's the bottom gray piece on this graph, but the blue piece on top that you see, those are the individuals that are held pretrial under a presumption of innocence in local jails. Next slide, Laura. So that's the big 40-year trend. I now want to sort of zoom in and talk about more recent trends looking at data in the last 10 years. So jail populations, and especially convicted populations, have been shrinking for the last 10 years or so, with really notable decreases in 2020 related to the pandemic, as we saw real concerns and shifts in policy and creating a focus on making sure that we didn't have crowded conditions in jails. Since then, we've seen that population start to tick back up a little bit, but overall the 10-year trend is still a downward trend. During this same time frame, again, we've seen a shift in increasing the proportion of jail populations that are individuals who are held pretrial. So in the last 10 years specifically, we've gone from 61% to what you see on the screen now, which is 71% of individuals nationally held in local jails are pre-conviction and pretrial folks that are held in jails. And so it's important to note that these individuals are not always necessarily detained intentionally after due process or a first appearance hearing, but sometimes detained due to their inability to meet financial conditions of release or other conditions, including supervision conditions, things like, do you have a mailing address or a place where electronic monitoring can be set up? So sometimes individuals are detained, but it's not necessarily the result of a pretrial detention hearing. One final metric in terms of data on who's in jail and looking at pretrial populations I wanted to mention, which is that 13% number, which is that last bullet, which is about 13% of all jail jurisdictions are currently operating above their rated capacity. That number has ticked up, especially since the pandemic, where we saw those significant drops in jail populations, and as those populations go back up, so too does this number of jails operating above their rated capacity. Next slide. This next piece, I just wanted to zoom in on the pretrial population specifically. And the first piece is on the left, which is looking at that 2021 National Bureau of Justice Statistics data for individuals who are held both pretrial and post-conviction in local jails. 76% of those individuals are held on a felony at mid-year 2021. But the image that you see on the right is put together by the Prison Policy Initiative, and they don't have their new updated one for 21 yet, so I'm including the 2020 image here. And this image really looks a little bit more closely at who these individuals are or what charges these individuals are held on pretrial. And so if we zoom in a little bit more, you'll see that the majority of folks are held on public order, property crimes, or drug offenses, with about 30% being held for violent offenses under that pretrial population stage. So that gives us an idea of the sort of offenses that are associated with individuals nationally, of course, that are held pretrial. Next slide, Laura. The other data that is of particular note across the country and in many other states is the rate of which individuals who have serious mental illness are held in our public jails, our public institutions. Rates of serious mental illness in jails are about 4 to 6 times higher than they are in the general population. And this disparity is particularly significant for women. When you look at female populations, the number of women, that disproportionate number goes up specifically. Jails in many communities are de facto mental health institutions. Oftentimes when there isn't a community-based resource in a particularly rural area or more remote places, jails can be the only response, or law enforcement can be the only response available in those communities when somebody is in crisis. And even if there are local resources, sometimes capacity isn't sufficient to meet local need in communities. And so jails and law enforcement responses are often the de facto backstop. I think the fact that illustrates this the most is that the 3 largest institutions in the country currently providing psychiatric care to individuals are the jail systems in Los Angeles, Chicago, and New York City. Next slide, Laura. So today I'm going to be looking at what states are doing, and also looking at this behavioral health set of things, but also pretrial, and diving into some of the state frameworks that we see, and also some of the trends that we've seen in states that are trying to address this problem. I'd like to take a moment to say thank you to Arnold Ventures for their support of NCSL. Without their support, NCSL wouldn't be able to have this type of briefing today. We also wouldn't be able to maintain our online databases. NCSL has 50 state databases, both on policing, including alternative responses, and pretrial policy, and we have statutory bases that cover aspects of both of those policy areas as well. So with that, I will say the state legislation by the numbers these two issues, it's something that's been addressed by every single state in the last decade. Every state has passed legislation to some degree, whether it was more narrow in scope or broader in scope. And what I'll say is, in terms of pretrial policy specifically, starting in 2017 and 2018, we see a shift not towards addressing this issue on the periphery, but in states really looking systemically at the front end, or this first point of contact with the justice system, and thinking critically about how law enforcement and pretrial systems are operating. And so we've seen a significant uptick in more comprehensive legislation in more recent years. Next slide, Laura. So today, these are some of the trends that I'm going to talk about, or areas where we know more than in other areas. And these are sort of the issue areas that I'll be hitting on. The first is individualizing the pretrial process, focusing on individuals themselves, and also creating statutory guidance for courts that are reviewing these cases and making determinations in pretrial policy. I'm also going to talk about conditions of release and the utilization of pretrial services. And then the idea that states are really considering who actually makes it to the point of a pretrial hearing and pretrial release, and thinking about narrowing that population. Are there ways that we can release people before that point, or that we can find alternatives in our community for individuals who may be struggling with behavioral health needs or issues, and finding an alternative for that individual as opposed to processing them through a traditional pretrial system. I'm also going to touch a little bit on constitutional structures and generally release detention changes in statute as well. And then I'm also going to talk about a more recent trend, which is responses to failure to appear. It's something that states are increasingly addressing, and it's probably the most recent aspect that I've seen shifting in policy. Next slide, Laura. So this first area of policy I want to talk about is this individualization of the pretrial process and creating statutes to guide court decision making. Here, the trends that we've seen is emphasizing an individual's risk of non-appearance and a risk to public safety over the category of offense, whether it's a felony or misdemeanor, or what that particular charge is, and looking at people as individuals. Also looking at ability to pay considerations if financial conditions of release are at play. And then also presumptions of release on recognizance and presumptions of release on least restrictive conditions. And then I'll briefly mention statutory factors for courts to consider during release, and also the use of risk assessment tools, which is one of those factors in many states. Next slide, Laura. So first, looking at the individualization of the pretrial process. The key trend here has really been that states are limiting predetermined amounts of money bail, or using bond schedules is another way of saying that, in states that are associated with the charge or the level of offense only. Sometimes bond schedules can be used to expedite release, and that has been sort of carved out in statute. Colorado is an example here where they've prohibited the use of predetermined amounts of bail or conditions, and have required courts to consider the individual circumstances of every defendant at this point of pretrial release. However, if a defendant could potentially bond out more quickly on a schedule, that is authorized. But if they make it to the point of their first appearance with the court, money bond is not a consideration for lower level offenses like traffic offenses and petty offenses. Georgia is another example. They've banned the use of predetermined bond schedules, specifically in domestic violence cases, requiring the court to take these individualized considerations into account in every case. Iowa is similar. They prohibit the use of predetermined conditions and schedules unless courts are not in session, and even then, there are certain cases where you still have to have individual considerations, including domestic violence or forcible felonies. Related to this, looking at individuals and their specific circumstances, what we've seen also is courts codifying an ability to pay consideration. And this meaning if a court decides or elects to set financial conditions of release, requiring courts to evaluate an individual's financial circumstances and determine whether or not the bail that's being set in that particular case is affordable for that individual, and if it's related to mitigating the risk of failure to appear. And so we have 13 states that fairly recently have enacted new laws requiring courts to conduct this ability to pay consideration. And that can be ability to pay and focusing on the individual's financial resources, what is their income, but also do they have dependents, what other obligations do they have financially as well for those individual defendants. This is also something that New Mexico, when they amended their constitution in, I think, 2016 was the year that that happened, was so important to them that they included this provision in their new constitutional language, essentially stating that if, we're not worried about the individual being a risk of flight, or if we're not worried about this individual being a risk to public safety, and the only reason that they're held is due to their inability to afford money bond, that defendant has a right of recourse through the state constitution now to file a motion and have their bond reconsidered by the court if that's the reason that they're being detained. Next slide, Laura. So presumptions of release on recognizance is also something that I wanted to address here. And essentially, this is a legal function that requires courts to start at the point of release, thinking about this person should be released and then work from there and overcome this presumption if necessary, if there are concerns about appearance or about public safety, but starting from a position of ensuring individuals who are presumed innocent pre-trial are released and released back into the community. A majority of states have codified this presumption in state statute, and in most states it applies broadly to all individuals who would be release eligible. We have 2 states that you see highlighted in green. It's Colorado and California, where this presumption applies only to misdemeanors. Next slide, Laura. So another part of this individualization and focusing on individual people going through the pretrial process, every state has a code section that lists out statutory factors for courts to consider when making release determinations. One thing to note, there's a few of them listed on here, I'll mention a few as I go as well, is that we don't have a lot of empirical research about the effectiveness of consideration of these factors in determining whether a defendant is going to be a risk to public safety or be at a risk of non-appearance. There are some factors that have been empirically studied and included in risk assessment tools where we do know more, but generally factors like the nature and extent of familial relationships or the character and reputation of the defendant in the community. We don't really know a lot about how those factors are used, and they're really hard to evaluate, but they do exist in every single state. In addition to those factors that are codified in every state, we also have some states that are increasingly prohibiting court consideration of certain factors. Here we have New Jersey that is an example, and they've prohibited courts from considering any previous marijuana conviction information or arrest information, including broader criminal history surrounding marijuana or hashish prior criminal history. New Hampshire is also a state that has recently moved to prohibit courts from using particular information in their determinations of dangerousness, which in that state could result in that defendant being detained. And the prohibitions there include evidence of drug or alcohol addiction and also evidence of homelessness. The state also specifically says that evidence of homelessness or lack of a mailing address cannot by itself constitute evidence that this defendant will not appear in court. So that's been the more recent trend. The statutory codification of these factors has been around for a long time, going back to Supreme Court case law in the 60s, but increasingly we are seeing the carve out of some of these factors, saying courts, we really don't want you to look at substance use or evidence of homelessness or prior convictions for substances that are now legal in those states. Next slide, Laura. I mentioned that I would touch on risk assessment tools, and this is one of those codified factors in a number of states. In the early days of looking at pretrial risk assessments and the use of these empirical assessment tools, we've seen about half the states adopt legislation, and in the earlier days, a lot of the focus was on requiring courts to adopt and use or consider a risk assessment tool. We currently have 7 states that mandate the use of a risk assessment tool. And then we see a shift towards, statute authorizing the use of a risk assessment tool, but not necessarily mandating the use of a risk assessment tool. And then more recently, we've seen another shift in states to authorizing the tool, but regulating the use of the tool to make sure that best practices are observed in terms of how the tools are used. And best practices have included things like regular validation of the tool, have included requirements that the tool be implemented in a way that is free from bias, and then also making sure that data, records, information, including the revalidation information about those tools, is publicly available, making sure that the public has access to those documents. And part of that transparency and public availability component is also making sure that a defendant has access to their own information about what was used to contribute to their risk assessment score. I should note, in states that have adopted a risk assessment tool, judges still retain discretion. There's no state that says you have to abide by the outcome of a risk assessment tool. And in fact, in Illinois and Pennsylvania, courts are specifically prohibited from only considering a risk assessment tool when determining pretrial release or conditions of release. Next slide. So now I want to move on to this next focus, which is conditions of release and pretrial services. And here I'll talk about the presumption of release on least restrictive conditions, statutorily authorized conditions of release and prohibited conditions of release, expanding pretrial services and how the role of pretrial services is changing right now in many states, and then the one area where we do have research and know about best practices, which is court reminder systems. And I'm probably going to talk about court reminder systems a lot because that's one of the areas where we do have the most research about what's effective. Next slide, Laura. So nearly half the states have now codified a requirement that courts impose the least restrictive conditions necessary to either ensure a defendant's appearance in court or to preserve public safety. These provisions require courts to consider individual defendants and their circumstances, and it's an express codification of law that transcends state statute. It's broad constitutional principles that support this notion as well. But these are states where they've positively codified it and said, courts, you must consider the least restrictive conditions when releasing an individual pretrial. There are a handful of states, not on this map, that don't have this presumption in place, but they assume that courts will start from a release on recognizance and then go up by degrees of more restrictive conditions and build from there as they make findings on the record that those are necessary conditions to serve one of the two primary purposes during pretrial release, which is ensuring appearance or to address public safety. Next slide. So first I want to talk a little bit about states' changes recently addressing conditions of release. And the first thing I want to jump in on is financial conditions of release. As of today, statutorily, every state currently authorizes the use of financial conditions of release. But we've seen states starting to move away from financial conditions in some limited measures, and we have one example of a state moving away from financial conditions entirely. So as I mentioned earlier, Colorado has been working to focus on some of those lower level traffic and petty offenses, and they prohibit the use of financial conditions, again, unless release would be more timely for the individual to bond out prior to that first appearance on a financial condition. New York has a much broader law. They address financial condition prohibitions for most misdemeanors with a few exceptions for, think, domestic violence cases or other persons cases. And then they also prohibit the use of financial conditions for some lower level felonies as well, again, with certain exceptions and carve-outs. Connecticut specifically limits the use of financial conditions of release for most misdemeanors. And they also say when financial conditions are used, you can't use a cash-only bond. Texas is interesting. They address the financial conditions of release for their municipal and justice courts, which handle some of their lowest level offenses. And there, they prohibit the use of bail bonds unless the defendant has a previous failure to appear on their record when the court is evaluating that case. And then there's an ability to pay consideration if a court considers using financial conditions of release. Illinois is the last that I'm going to mention because they're the most notable and expansive recent example. The Safety Act would eliminate all financial conditions of release in the state, but it's currently being litigated in the Illinois court system. So it would have been effective in January. The law is temporarily on hold in terms of implementation until they can get a final determination from the court. Something interesting to note about Illinois, it's also one of 5 states where there are no commercial bail bondsmen. It's illegal to make money off of posting a bond for somebody. So Illinois was one of 5 states where commercial bonding just wasn't a factor. And then the other thing that I should highlight is just because financial conditions are authorized legally in all jurisdictions currently right now, it doesn't mean that every jurisdiction utilizes them to the same degree. So we have examples of jurisdictions like Cook County, which is piloting the Safety Act, or New Jersey, and then the District of Columbia are all jurisdictions where functionally they operate without the utilization of financial conditions of release. But technically, those are still available in statute on the books in those states. Next slide. So now I want to talk a little bit more about statutory conditions and what's codified, but I want to start first with considerations of victim safety. So in a number of states that have adopted Marsy's Law or amendments to their Victims' Rights Acts, we've seen a real trend in the number of states requiring courts to consider victim safety when making conditions of release determinations in cases that are either victims' rights eligible or where there is a victim in that case. And then related to that, we see some conditions that are mandated and are automatically entered for certain cases. So an example related to some of the victims' work is no contact orders or prohibition of contacting the victim in domestic violence cases. In a lot of states, that's an automatically entered condition until the court can have a hearing to address the potential removal of that condition. Other mandatory conditions include focusing on the individuals who may be in line for a competency evaluation, and if they think that that individual can be released safely into the community, mandating that an individual comply and cooperate with the competency evaluation. And then the last example here is continuous alcohol monitoring, and this tends to be an automatic entry of a condition associated with DUI or other alcohol-related offenses. Prohibited conditions, meaning that courts cannot impose these conditions in certain cases, includes mandating an agreement that any financial conditions posted for a bond then later be used for restitution, court costs, and fees. And then we also have some states that prohibit mandating abstention from medical marijuana or other prescribed substances. Next slide. So pretrial services, I want to do just a brief little snapshot of history here. And so you'll see from the 1920s to the 1960s is really when we see the emergence of pretrial services. And the function there is the first function that most pretrial services agencies today serve, which is for individuals who could not afford financial conditions of release. Pretrial services agencies supervise those individuals. And then we see a shift after U.S. Supreme Court case Stack v. Boyle, and then in response to that, the Federal Bail Reform Act of 1966. And this is where we see another duty added to pretrial services agencies, which is to provide information to courts so that they can individualize their release determinations and focus on individuals. And so these are functionally today still the two primary things that pretrial services agencies do. They help provide information to courts to individualize release determinations, and they also supervise individuals who are oftentimes released in lieu of financial conditions on supervision. What we are seeing, however, though, is a shift in how pretrial services are utilized. And an interesting note here is that while the federal system with the Bail Reform Act of 1966 implemented, a countrywide pretrial services system, states largely didn't do the same. So they codified those statutory factors for courts to consider individualization, but they didn't create an agency at a statewide level to provide that information to courts. So in some states, courts themselves fill that role, or sometimes it's probation agencies. We do have a handful of states that are listed on the screen, including Alaska, Illinois, Kentucky, New Jersey, and Washington, D.C., that do have statewide or jurisdiction-wide agencies. But by and large, pretrial services are a local piecemeal function in a lot of states. But where we see the shift now is focusing not so much on supervision and the provision of information, but focusing on supportive services for individuals who are coming through the pretrial system. And this really means two things. Supportive services in terms of helping this individual make sure that they get to court and abide by court-ordered conditions. And so things like helping them figure out transportation or childcare so that they can get to court, or helping them find a time that they can get to court that doesn't conflict with their work schedules. But we've also seen this evolution towards supportive services and utilization of the pretrial phase as a way to do needs screening and identify individuals who might need greater support in the community generally, whether that's substance use treatment or other community supports, help with housing, some of those things. And while mandating that individuals engage in those supportive services isn't generally a function in the pretrial space, voluntarily engaging individuals and using this as one open door to build a connection back to community services is a trend that we are seeing in states. Next slide. So what do we know about pretrial services and what works? There has been an increasing amount of study, and I would recommend APPR is an organization that's funded by Arnold Ventures, who's done a lot of rigorous study on what works and doesn't work. And they have these really great research summaries that I can link to about what works. And that's essentially what I'm going to summarize here. Again, the one area that we know is really successful is court reminders. Your dentist does it. Your hairdresser probably does it. They send you a text message, an email, they give you a call to remind you that, hey, you have an appointment tomorrow. And that's also been really a successful tool in getting people to come back to court. Based on the evidence of this success, we have states now, whether they have a pretrial services agency or not, mandating the implementation of statewide court reminder systems. And so we have 6 states. It's Alaska, Colorado, Massachusetts, New York, Texas, and Washington all have statewide court reminder systems. And then an interesting approach, Maryland and West Virginia, that have state statutory infrastructure for the creation of local pretrial services programs. If a jurisdiction decides to engage and create a pretrial services program at the local level, that has to include a court reminder system. The sort of next step or the next phase of where we're seeing research and efforts going in terms of court reminders is to make them more interactive. Because if you get that text message that says you have court tomorrow, but you know for sure that you don't have a babysitter or you don't have childcare, what are you going to do about that? How can you address that situation? And so we're seeing local jurisdictions like Tulsa, Oklahoma as an example, where once you get that court reminder, you can respond to that court reminder and be put in contact with either a court navigator, or in some jurisdictions, it's the public defender's office, to help you overcome those barriers or find ways to make a court date that works for you. In terms of other research that we have available, pretrial monitoring, so meaning supervision check-ins with a pretrial services officer that supports and helps you comply with court-ordered conditions. We do have evidence and research to show that this can be effective in terms of reducing failures to appear, but not necessarily is that associated with reducing any sort of risk to public safety or rearrest. Research has shown us also that monitoring can be most successful with populations that are determined to be at highest risk of non-appearance. So in particular, in terms of how effective it is, it works especially well with populations that are at high risk of non-appearance. And then where sort of the jury is still out and we need more information, there's no clear association or research showing a connection between improved appearance rates and public safety with GPS location monitoring and also with drug testing. So that's where we don't have a lot of additional information or know about how effective those pretrial strategies are. Next slide. So as I mentioned, there was a focus on addressing individuals' needs before they even get to the point of a pretrial hearing and really funneling down. We talked about the individualization and spending a lot more time and resources making these pretrial determinations. But because that is so time intensive, states have also focused on narrowing the population that ever makes it to that point. And so today I'm going to talk a little bit about expanding community-based alternatives instead, and that's where the behavioral health nexus really comes in. Also talk about citation in lieu of arrest, and then creating expanded or delegated release authority. I'll also address the timeline. How timely are pretrial hearings when they do happen, and are there ways that we can make them more timely for defendants so they're not sitting in jail for a long time because there's just no capacity for the courts to have hearings in their case. And then also second look provisions. So individuals who have had that first appearance hearing but are still detained because they're unable to meet conditions, making sure that we don't just forget about those individuals and state statutes that have been put in place to require review and go back to those cases to make sure that those individuals have access to court review of their conditions. Next slide. So as I mentioned, thinking about addressing the greater need in the community before we get to the point of using the criminal justice system as a response. What you see on the screen here is called the sequential intercept model. And usually you see this in a linear fashion. It starts from in the community, it goes to law enforcement involvement, it goes to the point of arrest, pre-booking, jail, incarceration, reentry, and then back through to community corrections. And so it's sort of a linear model to think about the justice system and how folks work their way through this process. This model that you see in the funnel version here talks more about access to behavioral health services and where they should be the greatest. And so the top level here, ideally intercept 0, is where we would have the greatest access to treatment and community supports and resources, which is in the community before somebody ever gets to the point of having law enforcement called or having charges brought in a particular case, and sometimes even before they get to the point of crisis in the community, when there might still be a community response, but addressing the needs of individuals before they hit the point of crisis. The next part of the funnel is Intercept 1, and this is where we see law enforcement agencies getting involved. We've seen a lot of state action here too. You might have heard of the LEAD program in King County, Washington, so law enforcement assisted diversion, or CAHOOTS out of Oregon, down in Eugene, Oregon, or the STAR program in Denver. A lot of those programs started at the local level, but now states are really embracing them and putting funding or pilot programs and research behind expanding those programs and making sure that there's access to those programs on a statewide basis, not just in communities that have the resources to be able to support these kind of diversion efforts. And then Intercept 2 is where you hit post-arrest and initial detention hearings. I mentioned this can be a really important phase for pretrial needs screening, and that pretrial services play a big role in connecting individuals to voluntary support services. Vermont is actually an example of a state that's codified that process. Everything is voluntary in terms of the need assessment that happens and in terms of engaging in pretrial services, but they have codified the pieces in statute in Vermont saying we'd like there to be a needs assessment if somebody wants to engage, and we'd like to either offer up further, substance use disorder assessments or connections to care in the community if possible. And then as you move further through the system, this is where you get into more traditional pretrial diversion opportunities. And these are things that have been around, again, going back to the 60s. Pretrial diversion and treatment courts are not a new concept, but what we have seen is expanding access so that more individuals have access to treatment courts or are eligible for treatment courts, that there aren't charge or criminal history exclusions for individuals to be able to access those courts. And then the other thing that we've seen in some jurisdictions, and this is still mostly local, but there's been some state level interest, is addressing competency populations. And so Multnomah County, Oregon, there's a judge there who has what she calls her aid and assist docket, and it's for individuals who have pretty serious behavioral health needs. And her entire docket is specialized around addressing that population specifically. So folks that are going to go through, the linear justice process or the justice system, if you will, but maybe need a different approach to that system to be able to support them through this process. So at every intercept, states have been really active in terms of statutes and creating opportunities either to help people avoid justice system involvement, those front-end community-based needs or law enforcement-assisted diversion, but also some of those pretrial diversion and treatment court opportunities where if a defendant is successful and they finish the program, in most states, your record is then expunged and you don't end up with a conviction on your record, which can cause other collateral consequences down the line. Next slide, Laura. So the focus recently has really been on intercepts 0 and 1 and building a continuum of care before somebody ever gets to the point of having law enforcement involved or having strategies once law enforcement are the resource that's called out to address individuals' need in a way that just isn't arresting and booking that individual into jail. The way that states have been looking at this is to address gaps and using the state to backstop where there are gaps locally. And so the goal being to create a continuum of care across any point at which, no wrong door, any point at which somebody makes contact, that we have the ability to connect them with the supports and resources that they need. In particular, what you see on this screen here is what has been referred to as deflection strategies. So these are things like crisis intervention training for officers, creating co-responder teams, non-law enforcement-based mobile crisis teams, court navigators or case management folks who can be an ally or a peer counselor, helping somebody get connected to services. And then crisis stabilization units, which is another area where we've seen a lot of state action really taking on the role at the state level so that the need locally is filled in jurisdictions that wouldn't otherwise have access. Experts in the field have really focused on identifying some of the benefits of these strategies since it's something that has been more recent. And so locally around 2016, we start seeing these programs develop. And shortly thereafter in 2018, we start seeing legislative action and legislatures get involved in making these programs more permanent. But some of the benefits that have been highlighted by experts in the field include breaking the costly cycle of justice system involvement for individuals, increasing cross-system collaborations to create new pathways back to community-based resources, enhancing relations between community members and law enforcement, decreasing crime, incarceration, and recidivism rates, how often people have contact with the system, improving public health and safety overall, ensuring equal access to programming and resources regardless of race, income, or geography in a state, and also saving taxpayer dollars. And I'll just highlight a couple of state examples here, and I'm happy to provide legislation after the fact if you're interested. Utah is a state where I frequently highlight that has been particularly active in this area, and they've been working on legislation pretty much in successive sessions going back to 2012. And some of their most notable legislation happened more recently and was connected to the rollout of 988 in the state. But I'll just highlight a small portion of some of what they've done, which is they've supported their statewide mental health crisis line. They have a crisis line that the state operated prior to 988 coming online. That crisis line is staffed by mental health professionals, but they also recently provided funding for a warm line. And the warm line is for individuals who might need some support in their community, but they're not to the point of crisis yet. And so that line is staffed by peer counselors, people who have lived experience and understand what these individuals are going through and can maybe just provide some support or referrals into the community for those individuals. Utah also has what they call MCOTs, Mobile Crisis Outreach Teams. They're something that started a while ago in Utah, particularly in areas that had the resources to fund them and put them together. But this most recent round of legislation put together funding for MCOTs to be put into rural areas in Utah. And that included everything from providing funds for purchasing and maintenance of cars to helping staff those teams as well. And then the last piece I'll mention for Utah is their 23-hour crisis facilities. And they provided state-level funding for 4 crisis facilities to be located across Utah in the communities that were most in need of having access to those services. And this is an area where I'm starting to see more growth. Arkansas was the first state that I saw provide state-level support and funding for regional crisis triage centers. In 2017, they passed legislation to create 4 crisis triage centers across the state with regional access. And then New York is also one of the most recent states to address crisis triage centers at the state level. It's something that exists in many communities and has existed locally for a long time, but the role states have recently been playing is ensuring expanded access to communities who don't have access to those resources. Next slide. So the next thing, maybe, Laura, next slide. There we go. The next thing I wanted to mention is citation in lieu of arrest. And this is also not a new policy area for many states. You can see the rundown on the screen in terms of how the process is different. Instead of going through a traditional pretrial booking process, you get a citation just like you would a traffic ticket, and it gives you your information about how to come back to court. And that includes for misdemeanors, or in some states, authorization exists for felonies as well. And then there are 7 states that provide general authorization, and there's no specificity in terms of felony or misdemeanor designations. It's up to law enforcement officers to deploy citations. And what's interesting here is we saw a real uptick in the use of citation in lieu of arrest in the midst of the pandemic as a way to control overcrowding and population situations in local jails. And it's interesting because we didn't necessarily see a shift in state law in terms of what was authorized during that time, but we saw law enforcement policy change. And they started utilizing citations to a greater degree. And that's something that's sort of stuck with us from the pandemic going forward. And we're starting to see states not only expand when citations would be authorized, but also focusing on encouraging or providing presumptions that they are used in certain instances. Next slide. I won't spend a lot of time on the first piece of this, which is releasing people before first appearance, and bond schedules is one of the ways that jurisdictions have managed that by creating for lower level offenses, mandating at the state level, you should have a bond schedule for individuals to be able to be released prior to first appearance, and then making sure that if an individual can't meet that initial bond amount, having an opportunity for a hearing with court review of whatever the automated amount is, and then making sure that the defendant has access to counsel at that hearing. The next piece of this is delegated release authority, and I'll mention Utah here again as an example. Delegated release authority meaning somebody other than a court or a magistrate has the ability to determine release for an individual. This started in Utah as a population control measure for when jails got overcrowded. and they authorized the sheriff to, as sort of a release valve, release individuals. And the program was so successful that they codified it and expanded it. And so now local county executives can appoint members of the sheriff's staff as bail commissioners. Those bail commissioners can release certain individuals on their own recognizance, and they can also set financial conditions after consideration of an individual's circumstances, their case. And this authority exists for most misdemeanors and even some lower level felonies. So in Utah, they're releasing individuals before they ever get to court. Administrative release orders is something that's been more of a function of courts, and they can predetermine which individuals would be eligible for release by a pretrial services agency in their order. That's something that Kentucky utilized initially during the pandemic and then had so much success with that they stuck with it and have continued using a modified administrative release order in the state since then. And then the last piece I want to mention is the use of technology, and this ties into some of the timing of hearings. So Colorado first did a study about whether it would be feasible to have a 48-hour timeline from arrest to the pretrial hearing, because that's the standard of what would be ideal, is having at least a 48-hour or less timeline before you hit that initial point of being able to be released. And part of that study, the information they gained is not only how would this benefit defendants in terms of being able to get back to their community, not be at risk of losing housing, not be at risk of losing their jobs or having their kids placed into foster care if there's, the only people that are potentially able to care for their kids, but also looking at savings in terms of jail bed days for not housing these defendants longer than necessary just because we didn't have the opportunity to get them to court. So once that study came back, they realized that it was going to be really difficult for rural jurisdictions to meet that 48-hour standard. And so in the legislation that codified the 48-hour standard, they created a statewide position called a bond hearing officer that goes within the judiciary. And the bond hearing officer does bail hearings on weekends and holidays and prioritizes rural areas by doing AV connections like this, zooming in locally, or doing audio-visual court, and being able to set those release conditions in jurisdictions in Colorado that maybe only have a quarter time or a half-time judge. And part of that is Colorado has a statewide public defender system, so there was funding there to support counsel at all of those hearings. And then they created a grant program for district attorneys who might struggle to make sure that the prosecutor was also at that hearing as well. Next slide, Laura. I mentioned this earlier, which is the review process. This is, again, just a codification. If somebody has conditions set and they aren't able to meet those conditions within 24, 48, or 72 hours, requiring courts to go look again or authorizing a defendant to bring a motion and ask for review of those conditions to see if they can be changed so that they can be met. Next slide. And this we can skip over because I'm basically going to cover it on the next slide. But this is focusing on the constitutional frameworks that we have. Next slide, Laura. The constitutional frameworks that exist for pretrial policy. And what you see here is a map of the states. And so there are the 19 states in orange that are the right to bail states. And they adopted language stemming from the original 1682 Pennsylvania Constitution saying that all prisoners shall be bailable by sufficient sureties unless for capital offenses where the proof is evident or the presumption is great. As what is defined as a capital offense shrank over time, the right to bail grew. And this led to some states changing their constitutions to allow for greater detention. And so that's where you see the 22 states in blue that have this provision authorizing at a constitutional level additional detention. And then we have the 10 states, or rather 9 states and DC, that includes Hawaii, where it models after the federal constitution, and there's only the prohibition on excessive bail. There's no state constitutional right to bail. So this detention, net in or out, is controlled by the legislature at the statutory level instead of requiring a constitutional amendment. But next slide, Laura. What has happened to some of the state constitutions, I think, is mirrored in state statute as well. So I'll mention some of these, which is Alabama, New Jersey, and New Mexico, all recently, or relatively recently in the last decade, amended their constitutions to authorize detention and courts to detain individuals they're concerned about being a public safety risk. In New Mexico and New Jersey in particular, those were part of a broader pretrial package of reforms, one of those systemic reforms that I mentioned that really focused on risk of individuals, focusing on the individual process, reducing the role of money, and prioritizing release of individuals to get folks back to their communities and back to their families, their jobs, their housing. The amendment in Ohio and the one that is proposed in Wisconsin has more to do with what courts can or cannot consider. In some states, for a long time, public safety was not a consideration. Appearance in court was the only authorized consideration. We are now at the point where New York is the only state that public appearance is the only consideration at every point of determining release and conditions. Most other states have now modified their legal structures to be able to consider public safety. Next slide, Laura. And then the last thing I'll touch on here is responding to failure to appear. NCSL recently did a 50-state review of responses to failure to appear. And this is an area until very recently hadn't really been addressed in states. And so responses in terms of statute were modifying the bond, arresting the defendant, forfeiture of any money bail, suspending their right to drive, and filing new criminal charges. Until recently, though, we start seeing a shift in what some of those responses are, focusing less on the punitive responses that have been codified for a long time, and instead shifting to focus on a response that would actually help that defendant rectify the situation and come to court. And so here we see, again, expansion of court reminders and creating those interactive systems so that defendants can get over some of those procedural barriers or other barriers that might prohibit them from coming to court. We also see the creation of warrant grace periods, and Michigan is probably the most notable example here. They essentially hit pause, and for 48 hours, a defendant can voluntarily present themselves in front of a court. There's a presumption, essentially, that the warrant is not issued. A judge, if they're really concerned about public safety, can overcome that presumption if necessary, but generally speaking, oftentimes most people just forget to come to court, and once you send the notification that you forgot to come to court, most people will voluntarily show back up. There are a couple other states that have also put this in place. Examples include Connecticut and Georgia. There you get a day, basically, instead of 48 hours. And then the other piece of this is license suspensions. We've seen at least 8 states since 2017 remove license suspensions as a response to FTA, recognizing that oftentimes folks need the ability to drive to make it to court and to maintain employment and family responsibilities. And so that's another area where we've seen shifting. And with that is my last slide, which is just a connection to some of NCSL's resources. I'm happy to go into more detail on that, or I have some of our shiny frameworks reports, which highlights some of the big system structures in pretrial release. But thank you so much.
Thank you very much for your presentation. Members, do you have any questions? Senator? Senator
Rhodes.
Chair Rhodes?
Thanks. I was just curious on the Utah, you talked about their mobile crisis outreach teams. What do they do? How do they work?
I would have to go back to the statute and pull the exact information, but essentially, I want to say it's law enforcement paired with non-law enforcement mental health experts. I don't remember exactly what the qualifications, whether it was a social worker or an other class of mental health worker. But instead of responding with law enforcement, those units are able to be deployed to calls when an individual is in crisis. And so it's an alternative response to a law enforcement response in those states. But I'm happy to pull additional information on that for you, Chair.
Thank you. Thanks.
Amber?
Thank you, Chair Hashim. Amber, thank you for your presentation here this morning. In follow-up to Senator Rhodes' question on crisis intervention, I believe Seattle had one. Is that kind of a model that you're referring to in your presentation?
Yeah. Chair and Senator, law enforcement assisted diversion, LEAD, is the King County or Seattle model, and that was law enforcement led, but authorizing law enforcement to connect individuals to community care and be a conduit to a connection to the community instead of just having arrest authorized. And that's something that's been replicated in other states. California is a state that I think, they put I think the number is 15 million for 4 pilot programs. Colorado has also expanded the LEAD program, providing funding for jurisdictions to adopt that program statewide. And there are many other jurisdictions locally that have adopted that program as well. And I think New Mexico is the other state that appropriated funds to study the efficacy of that program and how it worked. And the LEAD model is also particularly unique because it is one of the models that has been studied and found to be really effective in connecting individuals to care and helping them to find more stable situations, including they're more likely to be in stable housing situations after having contact with the LEAD program. So I can share some of those research studies as well about that program.
Thank you. Thank you, Chairs.
Okay. Representative Souza?
Thanks, Amber, for that presentation. I just had a general question. At the macro level, where do you see Hawaii fitting into the landscape with our current laws in place as to these best practices? I mean, it feels like we're perhaps a little archaic compared to what you're talking about that is happening across the nation. Can you just kind of elaborate on that?
Yeah. Chair and Representative, I think Hawaii is unique because it's a unified correction system in terms of jails and prisons being one and the same. And I think it presents a unique opportunity because one of the things that other states struggle with is a really dispersed system, a very hyper-localized system. And so it's hard for me to compare Hawaii to other states because so much of the structure of the systems and how they work is so dependent on, in most other states, a local elected sheriff runs the jail. And sometimes you have locally elected judges in each of those jurisdictions. And so oftentimes we think about state law as setting a floor and a ceiling. And in those states, that tends to be what is important because the floor sort of sets the baseline of practice for all of those local actors. And the ceiling can sometimes inhibit in terms of state law and jurisdictions that really want to be innovative. And so I'm sorry that's a non-answer. It's not a great answer, but I think it does mean that Hawaii at the state level has a lot of opportunity to address some of what local jurisdictions have pioneered.
Thank you. That makes sense. Thank you for clarifying.
Thank you very much. Anybody else? Chair Tony?
Thank you, Chair Hashem. Thank you very much for being here today. I appreciate the description of what's going on across the country because it will help us to determine how best to move forward here. We're considering a number of measures in the House that Representative Ganadin has authored and others have proposed as well. One of them has to do with an appearance ticket in lieu of arrest. Could you speak to that in particular and the efficacy that you found in other states?
Yeah, so appearance tickets in lieu of arrest or citation in lieu of arrest is something that a lot of states have been exploring recently. Illinois, as an example, part of the Safety Act actually requires law enforcement officers to utilize those appearance tickets in certain circumstances, recognizing that individuals who they've selected that qualify for those appearance tickets were generally being released anyway after going through the entire process. They just had to go through the process first to get to that point. And so the greater utilization of appearance tickets and citations has really been a recognition that it's a different process for individuals who are going to be released anyway in a lot of circumstances. And there is a tremendous amount of law enforcement jurisdiction and discretion in terms of using those, but that's the new and interesting piece that we've seen is really earmarking or saying in certain instances we're going to use citations. And the other piece has been expanding access to citations so that law enforcement officers can utilize their discretion instead of just limiting citations to just these cases. There generally isn't like a mandatory thou shalt use a citation language, but there's generally a presumption that the officer can overcome if there's concerns about not being able to identify the individual, if they think that the individual presents a risk of harm to themselves or others, then a citation would no longer be the presumption. But in particular around, I want to say there's some data that was out of Los Angeles County that I can find for you, and the utilization during the pandemic of citations and the real impact that had on how crowded the jail was or what the jail population was or was not was pretty significant. And I think that's where a lot of lessons were learned during the pandemic and that we've seen shifting in not only state law, but also law enforcement policy, because the two work together in that particular area.
Yeah, maybe that's the one of the silver linings of the pandemic is that we can see what did work well and reduce prison jail population, perhaps. I am interested to see the implementation data, where the police have discretion to use it, but whether they do or not, I think you are gathering some data in that, aren't you?
I can definitely find data. I will mention the Safety and Justice Challenge run by the John D. and Catherine T. MacArthur Foundation operates largely in local jurisdictions. And in some of those local jurisdictions, it addresses the issue that I mentioned that many other states have, which is we have systems and not us systems. There's not a lot of great statewide data in other states. But jurisdictions that are engaged in that program have really robust data. And so I can look into some of those jurisdictions and see if I can pull some of those specific examples for you.
Great, thank you. And if I may, Chair, one last question. I would be interested to hear what your research plans are for trying to find an association between drug testing and pretrial location monitoring and improved pretrial outcomes. You say there's really no clear association that you found yet, but do you intend to do more research in this area? Could you let us know about that?
Absolutely. And Chair, Representative, I should clarify, that's not my research. NCSL's research is predominantly statutory and focuses on the legal frameworks, but the Advancing Pretrial Policy and Research Center, APPR, has compiled some of those research compendiums, and I'd be happy to put you in contact with their folks and the researchers who are working on some of that. So.
Okay, yeah, that would be very interesting for us to know. APPR sounds like a very useful source of information in some of these matters.
Yep.
That's all my questions for now, Chair.
Okay, thank you very much. I have a question. So you mentioned that women with mental illness are more likely to be incarcerated, or why is that?
Chair, I don't know if I can answer why. I should also highlight those 4 to 6 times in terms of rates of individuals who have mental illness in jail versus the general population. The 4 times is the men, generally the 6 is women. I'm not sure I can answer why, but the only thing I would highlight about that data and about the research is it's also just an estimate too, in terms of who in local jail systems have mental health challenges, because are we counting based on a diagnosis, or is it individuals who maybe haven't been diagnosed? And so I would just highlight that those tend to be estimates, and I think you could probably spend a long time deciding the reasoning, whether that has to do with the research itself and how those numbers were determined, or if there's something else there. But I'd be happy to ask in more detail and get back to you if there's
Okay.
anything I can find.
Thank you. Thank you very much. Members, any other questions? Seeing none, thank you very much, Amber. Representative Ganade.
Thank you so much, Amber, for flying all the way out here and joining us today. I had an opportunity to hear from you as well as folks from Arnold Ventures and MacArthur Foundation during the interim when I was hosted by the NCSL in Louisiana to talk about some of these issues. Can you talk about some of the ways that legislatures worked in a bipartisan manner to accomplish some of these things? I remember hearing a really excellent presentation by former Judge Berg out of Michigan, and he talked about some of the ways that that state used data to overcome what are usually like bipartisan talking points.
Yeah, absolutely, chairs and representative. There are a lot of states where we've seen bipartisan cooperation in the area of pretrial policy. I mentioned Utah in some of my presentation. Some of the legislation that was enacted in Utah addressing some of the behavioral health side of things was unanimously passed in both chambers across the entirety of the legislature. Some of the constitutional amendments changing pretrial frameworks were overwhelmingly passed by the majority of voters in the states where those issues have come up. And in terms of like the systemic reforms and big changes, or like in Michigan, the 48-hour grace period, lots of bipartisan support for pieces of this pretrial work. And a lot of that is based on where there's data. It was interesting because listening to the judge in Michigan at the meeting that we were at, the access to the data is becoming an increasingly important issue in some states, and also one of the biggest challenges in a lot of states, because there are these devolved systems and not a really good state centralized system to capture this data. And so that's one of the unique strengths, I think, of Michigan, or we heard from New Mexico as well, is that they have some of that really centralized data, and there was an ability to build a lot of consensus around changes in legislation in those states, because the data was very clear about the impact that some of the changes they were seeking would have.
I'm not sure if you've had a chance to review Hawaii's full statute, but in the last few years we've had some fairly monumental decisions by our Supreme Court kind of forcing the hand of law enforcement. Do you think that our statute is ripe for changing, like considering everything that you just presented? And if we don't change those things, do you think that our Supreme Court might might force us to do things like decarcerate like they did during the pandemic, or make other changes?
Chair's representative, I'm not sure I could comment specifically on Hawaii, but I will say that in the pretrial space and in the behavioral health space in particular, litigation has been a huge driver of change. If you look in the competency area in particular, in the True Blood case, and looking at states like Washington and DC, where they've had to appropriate funds for monetary damages in cases, or if you look at Texas or Georgia in terms of pretrial litigation and some of the changes that have been forced, I'm not sure I could comment on Hawaii specifically, but I will say that litigation and changes brought by litigation has certainly been a consideration in many states that have pursued pretrial policy changes.
Thank you so much. That's all I got.
Thank you. Members, any other questions? Seeing none. Amber, thank you very much. We are adjourned.